If you are a green card holder or even planning to become one, what you are about to hear could directly affect your legal status in the United States, your ability to travel, and your future path to citizenship. This is not a rumor, not a proposal, and not something that might happen later this year. A new U.S. immigration law was officially passed today, and it quietly changes rules that millions of green card holders have relied on for years without ever realizing those rules could change. Some of these changes take effect far sooner than most people expect, and one of them can resurface decisions you made years ago, even if you believed you were fully compliant at the time. Staying with this until the end could mean the difference between protecting your green card and walking straight into avoidable problems simply because you did not know the rules had shifted. A green card is more than just a piece of plastic. It represents the legal right to live and work permanently in the United States. For many people, it represents years of effort, sacrifice, and patience. But here is the part most green card holders are never clearly told. Permanent residence does not mean permanent freedom from oversight. U.S. immigration law is not frozen in time. It evolves with policy priorities, enforcement strategies, and technological changes. And when it evolves, the obligations attached to your green card evolve with it. For decades, many requirements were informal, lightly enforced, or handled only when someone applied for citizenship or traveled for long periods. That era is now ending. The law that passed today reflects a much broader shift in how the U.S. government expects permanent residents to prove, document, and actively maintain their status. This is not about creating panic, but it is about understanding that the rules you thought you knew may no longer be enough. In the next few minutes, this breakdown will cover what actually changed, why this law is different from anything we have seen in years, and what you need to do to stay protected in this new reality before ignorance becomes the biggest risk of all. Today's update matters because the law that just passed is not a routine adjustment or a technical footnote buried in policy language. It represents a structural shift in how green card holders are expected to interact with the U.S. immigration system on an ongoing basis. And before you assume this is just another announcement that will not affect your daily life, understand this. What changed today directly alters longstanding assumptions that millions of permanent residents have relied on for years without realizing those assumptions were never guaranteed. So, why is this January 2026 law fundamentally different from previous immigration updates? There are three reasons, and missing even one of them could create serious problems later. First, it changes compliance expectations that had remained largely unchanged for decades. In the past, many green card obligations were passive. You lived in the U.S., avoided major legal trouble, updated your address if you moved, and everything else was usually reviewed only when you applied for citizenship or traveled for extended periods. That passive approach is now gone. Second, this law formally introduces new verification and screening systems tied to travel and residency that were previously informal or inconsistently enforced. What used to be case by case is now written directly into law, which means discretion is replaced by standardized review. And third, and this is the part that surprised even experienced immigration attorneys, the law expands how far back the government can look when evaluating your compliance history, even if you believed older actions were already settled. All of this is happening within a much larger immigration environment focused on what policymakers are calling status integrity. In simple terms, that means the government wants immigration statuses to reflect real world behavior at all times, not just at the moment you apply for a benefit. If you are a permanent resident, the expectation is that the United States is genuinely your primary home. And that expectation now comes with clearer documentation and verification requirements. The first major change affects every green card holder, no matter how long you have lived in the United States or how carefully you followed the rules in the past. Under the new law, green card holders will now be required to actively verify their permanent resident status through a federal system every 24 months. This is completely new. Until now, most people only interacted with USCIS when renewing a card, updating an address, traveling for long periods, or applying for citizenship. Going forward, you will receive an official notice by mail, email, or both, asking you to confirm your current address, employment situation, and confirmation that you have not abandoned U.S. residency. The process itself is expected to take only a short amount of time online, but here is the key point. This verification is mandatory. Ignoring it is not a harmless oversight. Failing to respond within the required window can trigger a formal status review. That does not mean you lose your green card instantly, but it does mean your case moves out of the background and into active scrutiny. For someone who has always assumed their status was secure as long as they stayed out of trouble, this represents a major shift in how permanent residence is maintained. Something as simple as missing a notice because your address was not updated could create complications that never existed before today. The second major change involves international travel, and this is where many green card holders are feeling the most concern. Under the new law, any green card holder who spends more than 180 days outside the United States within a 12-month period will now be subject to enhanced screening upon return. This does not automatically mean denial of entry, but it does mean you should expect additional questioning and closer examination of your ties to the U.S. In the past, long absences raised concerns, but enforcement was inconsistent and often depended on the officer you encountered. Now that scrutiny is standardized. If you cross that 6-month threshold, you should be prepared to clearly demonstrate that the United States remains your primary residence. That includes evidence of ongoing employment, housing, tax filings, family connections, and clear intent to return. Walking into a U.S. port of entry without documentation after a long absence is no longer a risk worth taking. Another major change introduced by this law applies to specific categories of green card holders. Under the updated rules, certain permanent residents will now be required to submit brief annual reports confirming that the conditions under which their green card was granted still exist. This applies primarily to employment-based green card holders, investors who obtained permanent residence through programs like EB-5, and individuals with conditional permanent resident status, such as those who received a green card through marriage and are still within the conditional period. These reports are separate from your tax filings and completely separate from the new 24-month verification process. Failing to submit them can create delays, trigger additional review, or raise questions later when applying for citizenship. Compliance is no longer passive. If you fall into one of these categories, silence is no longer neutral. It can be interpreted as non-compliance. One of the most unexpected parts of this law affects people applying or planning to apply for U.S. citizenship. Previously, USCIS focused primarily on the 3 or 5 year period immediately before a naturalization application was filed. Under the new law, USCIS is now authorized to review your entire period of permanent residence when evaluating continuous residence and physical presence. That means travel patterns, extended absences, and compliance issues from years ago can now be re-examined, even if you believed they were already settled. For someone who received a green card 8 or 10 years ago and is only now applying for citizenship, decisions made early in your permanent residence, especially frequent or extended travel, may now carry more weight than ever before. So, what should you do right now? Start by confirming that your address on file with USCIS is current. Review your green card expiration date. Look at any upcoming international travel plans and begin building a simple travel log that records when you leave the United States, when you return, and why you traveled. Organize documents that prove your ties to the U.S., including housing records, employment verification, tax filings, bank accounts, and family connections. Keep both digital and physical copies. For anyone with complicated travel histories, extended time abroad, or upcoming naturalization plans, this is the moment to speak with an immigration attorney. Preparation now is far easier than damage control later. Let's bring everything together because clarity at the end matters just as much as urgency at the beginning. Today, January 23rd, 2026, a new U.S. immigration law passed that changes how green card holders are expected to maintain and prove their permanent resident status. The core changes are now clear. Mandatory verification every 24 months. Stricter scrutiny for extended travel outside the United States, new annual reporting requirements for certain categories of permanent residents, and expanded review of your entire green card history when applying for citizenship. These are not minor paperwork updates. They are structural changes that shift permanent residence from something passive into something that requires ongoing awareness and responsibility. But here's the most important thing to understand. This law is not designed to punish people who genuinely live in the United States and treat it as their home. If you work here, pay taxes here, maintain real ties, and respond when asked, you are not the target of this law. What you should feel right now is not panic or fear, but awareness. Awareness that the rules have evolved. Awareness that staying informed and organized is now part of protecting your future. And awareness that ignoring these changes carries more risk than the changes themselves. Millions of green card holders will navigate this new system successfully, not because they are perfect, but because they stay informed, respond on time, and take their responsibilities seriously. You can be one of them. If this helped you understand what just passed and why it matters, share it with anyone you know who holds a green card, because right now, ignorance is the biggest vulnerability. Leave any questions in the comments, and updates will continue to be shared as USCIS releases implementation details and real world guidance. Your green card represents opportunity, stability, and your future in the United States. Protecting it does not require perfection. It requires awareness, preparation, and action. Stay informed, stay compliant, and stay protected.